Guys, so it is the day before my first final exam, and I'm heading over to a contract review that my professor is having today. I'm late. It's like 10 o'clock and the review starts at 10 o'clock, but hey, I don't have to sign in, so it is what it is. It is super cold, like super cold. It's like low 40s right now, and yeah, I'm dying, so I'm doing the most. I live in Florida, but listen, when it gets cold like this, I pull out the up north attire. But yeah, I'm going through my studying. I feel confident right now. I'm in my stages of trying to finalize my memorization of the federal rules of evidence. I know it sounds crazy. I'm only up to, I have like the whole process kind of memorized. Like I know the rules. I can say rule 56 is such, summary judgment, 59 motion for a new trial. Like I can name them off my head, but as far as like memorization, I'm up to rule 12 right now. I went from rule 3 to rule 12. I can like list them off. I'm good at memorization, so I don't have a problem with that. So today's objective is to go to this review, finish that contract review, and then I'm heading to Starbucks with my friend Chanel, and we're gonna do Civ Pro questions and stuff. And then after that, I'm gonna head home, finish up my memorization of my federal rules of evidence, and then I'll probably start working on some property stuff because my next exam is Friday, torts, and then properties next week, and I already finished most of my stuff for torts, so I'll do tort / property. But yeah, tomorrow is my first exam, y'all. Wish me luck, even though you're gonna be seeing this after the exam, but I'll let you guys know how everything turns out. But so far so good. I don't feel too bad or anything about it, so I'll let you guys know how it goes. So actually, no, I don't have I don't have a review session today for contracts. I just got to school, I'm looking in the rooms, and I'm like, there's no one here. No one is here. So I text one of my friends, and he's just like, yeah, that's next week. And actually, before I texted him, I went and I checked the email to find out that, yeah, it's gonna be next week because our contract's final is not until next week, Thursday. So yeah, this is just how final brains work. You know, I got up early this morning, like did study, and I was like, all right, I gotta get to this review, do that, knock this out. No review today, but I'm already here at school, so I'm just going to finish up my memorization and studying until my friend hits me up to go to Starbucks. And I'm just gonna, power through the rest of the day and do what I gotta do. So yeah, our school opens up certain classrooms during reading week and final week for studying that you can, there's some rooms quiet study and some rooms where you can go and do like group studying. So I'm in one of those rooms right now, and I am just about to knock out the Civ Pro studying. My final hoorah exam is tomorrow at 9 a.m. Yeah, so that's gonna be me for the remainder of the day. Civ Pro all day. This is what that's looking like. My outline on deck, my federal rules of civil procedures, and my Q&A for Civ Pro. That's my setup, and that's what I got going on. So I'm just gonna turn this into a study with me. So finals study with me. So right now I'm just gonna go over my rules that I have memorized, and then I'm gonna continue to go down the list of rules. Okay, so Federal Rules of Civil Procedures 3. Okay, so a civil action is commenced by the filing of a complaint, Rule 3. Rule 4 discusses the summons process. 4A1 talks about the contents of a summons. There's 7 criteria criteria. 1, the name of the parties, the name of the court. 2, it must address the defendant. 3, it must state the plaintiff's attorney's name and address, or the plaintiff if they are unrepresented. 4, it must state the time in which the defendant must appear to defend. 5, it must detail that if they fail to appear and defend, that default judgment would be entered for the amount in which the plaintiff sought relief. 6, the clerk's signature must be present, as well as 7, the court's seal must be present. Rule 4A1. 4A2 is amendments. The court may permit amendments of summons. 4B is the issuance of summons. So after a complaint is filed, the plaintiff's attorney would submit the summons to the clerk. If it is complete, the clerk will sign and seal the summons, give it to the plaintiff's attorney to be served on the defendant or defendants. 4C outlines the service of the summons, and 4C1 says that a copy of the complaint and the summons must be served on the defendant within 90 days of the complaint being filed. 4C2 states that a person that is a non-party and at least 18 years of age is capable of serving process. And 4C3, that a U.S. Marshal is also able to serve process. 4D talks about the waiver of service, and this basically details that the plaintiff's attorney may send a waiver form to the defendant to waive service of process. They must send in this waiver, it must have the defendant's name, it must have the court's name, it must give the defendant 30 days in order to return this waiver, 2 copies of the waiver with a sealed envelope, 1 copy for the defendant to keep, and 1 to send back to the plaintiff once they sign that waiver. The waiver basically gives, if the waiver is signed, it stipulates that they will not have to be formally served by a U.S. Marshal or someone else, and it will allow the defendant an additional time to respond. It gives them 60 days to respond versus the 21 days that they would originally have if they do sign that waiver. Once the waiver is signed, it is sent back to the plaintiff's counsel, who will then file it with the clerk. If the waiver is not signed, failure to sign the waiver, which is 4D6, failure to sign the waiver, the defendant will be liable for any attorney's fees that may incur, or and they are liable for the payment of the service of process. Yes. So that is the gist of Rule 4. No, it is not. So 4E talks about who can be served in the domestic realm in the United States. 4E 2A says that it may be served personally upon the defendant. 4E2B says that it may be served on someone who is within or resides at the defendant's dwelling or usual place of abode. 4E2C states that it may be served upon an agent of the defendant. 4F is talking about the service of persons in foreign countries. 4G talks about the service on incompetent persons and minors. 4H talks about the service of process on businesses and corporations. 4I talks about service of process on the United States. 4I1 talks about United States as a party. 4I I-2 talks about service of process on a employee of the United States being sued within their title as an employee of the United States. And 4I-3 talks about service of process on an employee being sued individually outside of their role of title working for the United States. And that wraps up the gist of Rule 4. Moving on, Rule 6 talks about the counting of time and extension. So Rule 6A states that the court time for whatever date, whatever event, the date of the event triggers when you start counting. The last day of that event, the date that triggers the beginning of an event is excluded from being counted. The last day is included, even if it is an intermediate, if it's a Saturday, a Sunday, or a legal holiday, except for the fact that, So Rule 6A says that the date that triggers, you exclude the date that triggers the event. You add the last day of the event. You add Saturdays, Sundays, and legal holidays. You count those as well as days in the event, unless it is on the last day of the event. If it is on the last day, then you'll count the next business day after, right? You're given 3 additional days if you file by paper. If you send it by mail, you deliver it to the clerks, or something else that's agreed upon between 2 parties. 6B talks about the extension of time. So the court may grant extension of time on any motions except for the 28-day period after the entry of final judgment to make a motion of renewed judgment for a motion for renewed judgment of matter of law, a new trial, amendment to judgment, amendment to findings of a non-jury, and a motion for a new trial on the court's initiative. So those may not be extended at all, but all others under 6B, there could be extension of time. Rule 7 talks about pleadings and motions and other papers. 7A talks about the pleadings that are allowed. There are 7. 1, the complaint. 2, answer to the complaint. 3, answer to a counterclaim. 4, answer to a cross-claim. 5, a third-party complaint. 6, answer to that third-party complaint. And 7, an reply to an answer if the court orders one. And then 7B talks about the motions and other papers, that if there is a request for a court order, it must be done by a motion, in which must be written unless, 1, it must be written unless it is done in a hearing. 7B2, it must state the grounds on which the motion is being made. 7B3, it must state the relief in which is being sought. Rule 8 talks about the general rules of pleading. Rule 8A talks about the claim of relief. So any pleading that is demanding a claim for relief. A1 says that it must state a plain and short statement of the court's jurisdiction, which is basically, oh Lord, why is it dark in here? Subject matter, jurisdiction. 8A2, a short and plain statement of the claim in which the pleader believes they are entitled to relief. 8A3, demand for the relief sought. 8B talks about the defenses and admission or denial. 8B1A states that there must be a stating of a clear and concise defense to each allegation. 8B1B says that you must admit or deny each allegation. 8B2 says that the denial must be made on substantial ground. 8B2, denial must fairly respond to the substance of the allegation. 8B3 talks about general and specific denials. General denials is if you're denying everything, including the jurisdiction. Specific denials, you can deny specific items of the allegation, or you can deny generally except for the things that you would admit to. That's 8B3. 8B4 is partial denial. 8B5 is lack of sufficient knowledge, which must be stated, and it serves as a denial, saying that there's not enough information to admit to. 8B6 is the failure to deny, and in a responsive pleading, if you fail to deny, that is an admission. So if you do not deny something, it is constituted as an admission by the court. If it is not a responsive pleading, then it is treated as a denial or avoiding. 8C is affirmative defenses, and there are a whole list of affirmative defenses: duress, estoppel, failure of consideration, etc., etc., etc. And then we move on to Rule 11. So Rule 11 talks about the certification of documents being presented to the court. And Rule 11A talks about the signature of the attorney. The attorney must sign each document that it presents to the court. Their signature is a certification, and their name must be present, their email address, their address. Rule 11. Email address, telephone, and their telephone number. Under 11B, it stipulates that basically the attorney did the due diligence to investigate that the claims being sought and the documents being brought are not 8B1, brought for improper purpose, whether it be delay, whether it be for harassment, or to cause undue expenses in litigation on the other party. 11B2, that it has a legal contention which is warranted by existing law. So basically it's a non-frivolous action being brought. And 3, that the allegations have evidentiary support or will have evidentiary support. 4, that denials have evidentiary support or will have evidentiary support. 11B4, right? And then 11C talks about sanctions. So if a party is seeking sanctions for an attorney bringing an improper, document for harassment or whatever it is, they cannot automatically file a motion for sanction. Sanctions by the court are to deter, not really to punish. However, if the party must bring on notice the other party of what actions they feel is sanctionable and give them a period of time to correct that behavior. If not, then they may file a motion to sanction with the court. Right? I think so. And this sanction is on the attorney and not the client. Sanctions can be on the attorney, the law firm, or the party who violated. Okay. So 11C2 is the actual motion for sanctions. Okay, and then 12B defenses. So 12B has 7 defenses, 12 for motions to dismiss. So 12B1, a motion to dismiss based on subject matter jurisdiction. 12B2, a motion to dismiss based on personal jurisdiction. 3, based on venue. 4, process. 5, service. 6, failure to state a claim in which relief can be granted. And then 7, failure to join party. And that's all that I have studied so far, memorized so far. So I'm going to continue to study the rest, memorize them. I feel confident with those rules. I might show you guys some more snippets of me studying, but that's basically what I'm going to be doing today. Going through the rules, going through my outlines, memorizing them. You know, obviously I have all of that stuff memorized already, each rule and its subsections and what says what. That's the process that I'm doing for CivPro, and that's how I'm studying for CivPro, because our exam is going to be all multiple choice this semester, and then next semester we're having CivPro 2, in which we're going to be having essays. So yeah, that's just a little insight, well, a lot of insight, because that's exactly how I'm studying for CivPro. I showed you guys my outline already, and this is how I'm memorizing. It might not work for everyone. I'm good at memorization, so for me, once I have everything laid out and I can visualize and, you know, repetition and stuff like that, I'm good with memorization, so that's gonna work for me. Might not work for you, but it's a way to do things, and that's gonna be it. Thank you guys so much for watching my video. Or maybe I'll continue. If not, you know, continue to watch. But don't forget to like, comment, and subscribe. Let me know down below how you think you're gonna be, how you think you're gonna approach your finals. Well, you might not know, but what are your study styles? Let me know down below how you study and what works best for you. Let me know if you think I'm crazy for studying the way that I am studying. Yeah, let me know down below.